court. And I'm joined by ABC15's Lillian Donahue, who is back at the station. I'm here outside of court right now. I want to mention that ABC15's Ashley Holden is inside. We are still waiting for the day's deliberations to get underway, Lillian. But of course, I want to point out real quick, the important thing that we're trying to figure out right now is Lori Daybell going to officially rest her case like she said she would last week? The judge giving her that weekend to decide for sure, because Lillian, the reason why we're paying attention to this so closely is because this would mean that Lori Daybell is not calling any witnesses in her defense, and she's also not going to testify in her defense. That's what she alluded to last week, but we don't know, Lillian. Of course, this could all change.
Yeah, I mean, honestly, the word of today is flexibility, and figuring out what Lori Daybell is deciding to do. For those who haven't been following the case, just a quick recap on everything. Lori Daybell has already been convicted of in three murders. So she's been convicted in her two children, and then a third as well. Now those were in Idaho. Now she's here in a separate case. This is her fourth husband that was shot and killed by her brother, Alex Cox. Alex Cox at the time said that he was acting in self-defense. Cox has since passed away. Daybell is still saying this is self-defense. This was a family tragedy. The state is saying, though, that she conspired with her brother, Alex Cox, to kill her fourth husband, Charles Vallow. And that is what we have been paying attention to over the past 2 weeks. And that's what we're moving into now is, the prosecution rested last week and Daybell immediately was like, I rest. But then she recanted and said, well, give me till Monday. So that's where we're at now is we're going to see, does she have a defense? Does she not have a defense? If she continues with the statements that she gave on Wednesday and on Thursday that she still plans on resting without testifying or without bringing a witness, then that moves us into the next phase of things, which will be jury instruction and final closing arguments. I'm very fascinated, Nick, to think about what those closing arguments are going to be. I mean, how do you feel like it's going to go? I mean, you're there right now.
Yeah, we know the prosecution said last week that they predict their closing arguments would last about an hour. Lori Daybell said hers would be much shorter than that. And really, the idea of the closing arguments is that's really your last chance to try to convince the jury of your side of this, right? So the prosecution is going to go over, key evidence that they had. They're going to sort of summarize what the witnesses have said and really try to hammer home those central arguments of the case. And I would imagine what Lori Daybell wants to try to do is continue to try to poke holes in the case, which is what she's been at least attempting to do representing herself in the courtroom, because we know the burden of proof in a criminal trial is beyond a reasonable doubt. So what Lori Daybell wants to try to do is create some sense of reasonable doubt that no, she did not plot to kill her fourth husband alongside her brother, because that's what the prosecution obviously has alleged here, and she has pled not guilty to that. And that's why we're here right now.
And Nick, she only needs one person to say, I got a little doubt here in order to be successful for her in this case.
Yes.
And so in looking at her strategy here, it seems like she's trying to honestly make her case without having to have cross-examination and open herself up to that cross-examination from the prosecution, who very experienced prosecutorial team here. So
that's a good point, Lillian.
Into court here. Yeah,
that's a good point, because if she does, in fact, decide to testify, again, we're still waiting to see if she does. She made it sound like she wasn't going to. That could change. She could have had a change of heart over the weekend. But Lillian, you bring up such a good point, because if she decides to do that, even though obviously it's an interesting case because she's representing herself, and then she would be essentially her star witness as well. But the prosecution would then have a chance to cross-examine her. And there may be some questions that she doesn't want to answer, wouldn't feel comfortable answering, or maybe feels like doesn't help her case. So I think that's really a lot of what's weighing on her and that decision as well.
So the big question is right now, right? So court has just begun and we're waiting to hear from Ashley Holden, who has been incredible at reporting all of this and keeping it up to date with us. But should we hear from in the next few minutes that she is not going to testify? She did not find someone over the weekend to take the stand for her. She's not going to have a defense. She's going to rest, and that they're going to move into jury deliberations after closing arguments after lunch.
Yep.
Could we see a verdict today?
What I would say is anything is possible. I do think the chances of that are very slim, right? Because the jury, or, I'm sorry, the judge has already said that we're not going to start those closing arguments until after lunch. And if it takes the prosecution an hour, if it takes Lori a little less, they would still need to deliver the jury instructions. And we don't know how long the jury would deliberate. Again, it's just one count. It's the conspiracy to commit murder. That's the only count that's being tried in this case. But the thing with a jury, whether it's a criminal trial or a civil trial, it's always the great variable, right? You never know exactly how long that jury is going to take to render a verdict. So, sure, is it possible? Yes. Is it likely? Probably not, but stranger things have happened. And just a couple of quick housekeeping notes. I want to let you know that I'm going to be live at 11 o'clock on ABC15 on our 11 o'clock news with Megan Thompson. And then once they go to recess, right? So once we figure out what's going on, if Lori's going to testify and we go to recess, Ashley Holden's going to join us, but we're going to have round 2 of this live discussion once again with Lillian. And then we're going to bring in ABC15's Ashley Holden as well and have a conversation really about where we are, how we got here, and what comes next. But I just want to let you know that. And then, of course, we'll have team coverage throughout the day today and tomorrow, if this moves into tomorrow, as we would then be on Verdict Watch.
Yeah, we're going to be here every step of the way. Any update, we're going to head on this stream and talk to you. We have an expert panel set up at for the noon hour, for that whole lunch hour before closing arguments to break down what we know so far and what those closing arguments could look like. We have the former prosecutor from Idaho in those other cases that I spoke about earlier. We have a local defense attorney who has plenty of experience in murder trials as well. So there's going to be a lot of good expert analysis that we have in that show as well. But I want to bring in just a little bit. So Ashley Holden actually interviewed what that former prosecutor from Idaho and asked the questions of, what's next? The same thing we're talking about right now. So let's bring up Rachel Smith and see what she has to say about Lori Daybell's plans.
Intent is to rest without bringing any witnesses or evidence. Do you think that's really what she's going to do?
Lori Vallow Daybell is always got to be in charge. We saw that in the decision to represent herself. We see that in the decision not to testify, because if she testifies, she gets cross-examined and she's not going to let anybody else shape her narrative. She also is going to really focus on her closing argument. She's going to stick by what she said in opening, which is this is a tragedy. She's going to allude to the fact that she didn't plan for Charles to die, that Alex was acting in self-defense. And even if Alex was wrong in what he did, she certainly didn't participate in the planning. So what's happened over the last couple of days, last week, has really been quintessentially Lori Vallow Daybell. It's Lori's world, it's Lori's narrative, and she's going to stick with it and ride it all the way to prison.
So you don't think that come Monday she'll be taking the stand?
I really don't. I mean, there is a degree to which Lori could be being cute and thinks she's pulling a fast one and change her mind on Monday. But I stick by my statement I've made a few times. If Lori testifies, Lori's no longer in charge. Lori opens herself up to cross-examination from a very experienced homicide prosecutor who knows Lori's iCloud better than Lori does. She's got to be aware of that. She's got to be aware that if she opens herself up to cross and tries to take the fifth or tries to evade, even if she's quote unquote cute about it, the jury will see that and it will hurt her. Strategically, she would be foolish to open herself up to Trina K. I believe instead she's going to try to have her say, make her argument in closing arguments. We'll probably see a lot of objections. She's testifying, judge, facts not in evidence. It's going to be very interesting to see how the judge handles it. I think Lori's going to try to testify, just to lie in closing argument.
Fascinating, right? That she is saying that she believes that Lori is going to basically try and quote unquote not take the stand, but take the stand and make her testimony her closing argument without having to face that cross-examination.
Yeah, which is an interesting legal strategy. Speaking of, I just want to mention, as you've been saying, Ashley Holden is inside the courtroom, and she said right now court has started, and they're beginning with some modifications to jury instructions, but that Lori Daybell is still intending to rest her case without calling any witnesses and also without testifying herself, which is just what that prosecutor from Idaho was talking about. And that's what she predicted, Lillian. She didn't think that she would want to testify because, again, the point that you brought up earlier is that she would be cross-examined and she would have to then lose control of the narrative, so to speak.
Interesting. So, also getting more information from Holden this is all live as she's sitting in the courtroom. She's telling us that Lori is now expressing some concern on her interview that was entered as evidence. So we watched that video back and forth between the investigators and Daybell. I think that was last week or was the week before. It was during some of that examination there, but she's challenging it, saying a witness may have said this was the full interview rather than a clip taken from that full interview. The judge said that she could have cross-examined the witness, and other aspects that are considered hearsay have been redacted. So it looks like she's pushing back on some of the prosecution's witness testimony. She's trying to find, like you said earlier, those holes that she can poke and hopefully expand to add that reasonable doubt in there. She looks like the judge did say that there were some parts that were considered hearsay that have been redacted. But the judge is also standing firm, saying you could have said this at that time.
Yeah, I was going to say that's the hearsay argument. It's interesting, but from what Ashley Holden is saying from inside the courtroom, it sounds like the judge is going along with at least part of that. So, at the end of the day, maybe some of this argument would be successful for Lori Daybell. But interesting insight there from Ashley, and also that the prosecutor who predicted that this is sort of what would happen here, because as you mentioned, and if folks are just joining us, what's going to happen is once she officially decides that she's resting, which it sounds like she's still going to continue with that, but they're just kind of going over some motions. Once she officially decides, then we would have closing arguments, which will not start until sometime after lunch. And then we're going to hear from the prosecution. They think they're going to last about an hour. And then Lori Daybell, she said she's not going to go as long as that, but who knows? Obviously, we have to wait and see. But it'll be interesting because you've been following this so closely, Lillian. So it's been very spirited at times to see Lori cross-examine, my goodness, one of her brothers, family members of Charles Vallow, a woman who went on a date with Charles Vallow right before he died. That has all been very interesting because it's deeply personal.
Yeah. And you're going to want to stick in for this whole stream because right before we hit the courtroom, just before 11, we're going to see all of the highlights from all of those people in court. But Nick, why don't we walk through last week?
Yes.
Where did prosecution end up and what were the final witnesses that they were bringing forward to try and put the nail in their coffin?
Yeah, I'll just go through the list real quick, Lillian, since I'm going to have to cut out in about 8 minutes to get ready for our 11 o'clock show. As I mentioned, I'll be live here from the courthouse for that. But let's start with last Monday, which was day 5. We are from the medical examiner, which is really interesting because he was able to lay out some of the forensic evidence that talked about the shooting death of Charles Vallow. And even though Alex Cox insisted it was self-defense, what the prosecution was alleging through that medical examiner's report that there was at least one shot that was fired while the victim was on the ground. And their argument is, well, why would that need to happen? If he was already incapacitated, why would you then need to shoot even more? We also heard from... Oh, go ahead.
Nick, that backs up what the those who were first on scene, the first responders and the homicide detectives that were there the week before said, we believe the second shot was on the ground. And so then you back it up with that evidence from the autopsy saying, oh yeah, the wound is consistent with him being against a flat surface. It's very kind of
which would conflict with the version of he was coming at me with a baseball bat, so I had to shoot him twice to incapacitate him. And again, Lori's alleging it was self-defense. It was a family tragedy, as you mentioned, Lillian, but police investigators have a different story. We also heard from a special agent with the Social Security Administration. So this was the prosecution's alleging that there was sort of one of the motives possibly was that Lori may have gained financially from some of this by not disclosing that she had remarried and that so she would still be able to collect some checks. And so that special agent testified that they were not made aware that she had, in fact, married again for the fifth time. And then after that, we heard from one of the first of several Chandler PD detectives. And Lillian, this detective, was testifying basically on Lori's demeanor when they arrived at the scene and when they were interviewing her. And the word from that day was nonchalant, because they kept saying how that was how she was acting. And the reason why they bring that up is because, you would think if your husband had just been killed, even in self-defense, you would still be upset about it. You'd be showing emotion. She was not. She was sort of matter of fact about it. But then her argument, her rebuttal to that was, well, basically, who are you to say how I mourn? People are individuals, which I thought was an interesting argument, Lillian.
Yeah, she said that, grieving looks different for everyone. And that was something that she was really trying to hone in on to try and poke holes in that witness, was like, well, if I was nonchalant or not has nothing to do with conspiracy case, has nothing to do with that. It just, basically try and throw out that whole witness in the minds of the jury. And so she's trying to do that again a little bit, with some of this stuff. So in looking at her whole argument, even though she hasn't presented her argument in full, has come in the form of the cross-examination, which at times has been really contentious between a few people. I think that there's somebody in the courtroom that's pretty interesting. Yeah, Nick, what are we learning now?
Yeah, so Ashley Holden in the courtroom telling us that Brandon Boudreaux is in the courtroom with Kay Woodcock. Okay, so let's break down who these people are. Brandon Boudreaux is the ex-husband of Lori's niece. We've mentioned before, this is Lori's first Arizona trial. There's going to be a second one. And just Thursday, the judge set the dates for that. It's going to be May 30th. Okay, so it's going to be about a month from now. But Brandon Boudreaux is important in that case because the charge against Lori is another conspiracy to commit murder. So the prosecution in that case is alleging that Lori also plotted to kill the ex-husband of her niece, Brandon Boudreaux. So he was in court in day one. He's back in court. And then also Kay Woodcock is the sister of her former husband, Charles Vallow, who was killed in this case. And she also testified. And that was also very spirited because they had asked her, Lori had asked her, did you see any evidence that I conspired to do this? Or something to that effect. And I forget what her answer was, but she basically said, well, I saw a lot of evidence to support that.
Yes.
And that's her brother. Her brother was killed in this.
Yeah. She asked point blank to Woodcock, if you've seen me directly conspire to kill, and she's like, no, but the evidence points towards it. And that's very fascinating. We'll see that in a few minutes. Nick, thank you so much for joining us. We're going to let you hop off right now to let our TV viewers know what's going on, but I'm going to stay here. We've got some more analysis going on here, but you guys, so for those who are just joining us, just in a few minutes, we're going to go into the courtroom for the Lori Daybell trial. Prosecution has rested. They rested last week, and throughout the end of last week and even this morning, we're finding that Daybell is not planning on testifying. That's a big deal because she is her own counsel right now. So she is acting like her own principal attorney. She's been doing all of the cross-examination. It's at times been quite, you can feel the tension in the courtroom as she's interviewing a lot of these people. Nick was talking about the people that we were going through. Let's finish up with what the prosecution was able to, who they brought forward at the very end of last week. And then we'll go into kind of like this highlight portion to hear directly from what happened in the newsroom, or not newsroom, but in the courtroom. So on day 7, they wrapped with the homicide detectives with the Chandler PD. That was their big final, the prosecution's big final witness, who talked a lot about his evidence and how in his investigation it pointed toward the fact that there were discrepancies in her timeline, the fact that she went out and went to Burger King and all of the stuff, and they looked at her emails between her now husband, Chad Daybell, and it looked like it came from her then husband, Charles Vallow. So there was a lot of specific evidence between emails, texts, phone pings. They took phone pings to say, hey, at this time she was up here. And if the authorities believe that Vallow was shot at the house at, this time, well, that means that she was gone and not there at that time. Now, if she wasn't at the house, when Vallow was shot and killed, that would mean that she gave a false testimony on the day of the shooting to police because, as we heard earlier in last week, she told detectives that she was there when it happened. But it seems like there's that kind of discrepancy that hasn't really been resolved. And that's what prosecution was trying to pull out here. So let's go. I just got a note from Holden. She hasn't officially rested, but is saying that she won't be taking the stand. So remember that word for today that I said that we have. We have flexibility. As I'm hearing in real time what's happening in the courtroom, remember we have a 30-minute delay. So as soon as 11 o'clock rolls around or a little bit before then, we'll hop into the courtroom to see what's happening. But Holden, who is in there, Ashley Holden, our reporter, is telling me that she hasn't officially rested, but she's saying she won't take the stand. So in the next few minutes, we'll kind of get more of a game plan on what's happening. And I want to remind you guys, at noon, we're going to have expert analysis from 3 amazing experts in the field, including the former prosecutor in Idaho who actually led to 3 convictions for Daybell in the case of her children, and another person as well. So to not go down the rabbit hole over there, I mean, this has been a 6-year thing. Now that we've wrapped up how all of this case came together, I want to take you back into the courtroom for kind of a highlight reel of all the different moments, starting from the beginning where she said this is a family tragedy, all the way through to the end of last week. Here's what you're going to see in this video. You're going to see Charles Vallow's sister. You're going to see Lori's other brother who took the stand and said that he has no doubt in his mind that she did it. You're going to see multiple experts who are breaking down text messages. You're also going to see a woman that went on a date with Vallow the day before he passed away. And then you'll see a little bit from that Chandler detective that wrapped up the prosecution's witness testimony. All right, why don't we take that as well right now?
Family tragedy is not a crime.
Lori and Alex knew exactly when this murder would happen and where it would happen.
Did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
All these things all added up into that moment and that morning. No doubt on my mind that they killed him.
Either the shooting did not happen that close in time to the 911 call, or that she wasn't there for the shooting.
It was probably Ned before we got rid of him.
Did you ask me what I meant in those text messages?
I couldn't.
Okay. So you spent your whole date getting to know each other, talking about me.
Don't flatter yourself. No, we did not spend the whole time talking about you.
And you weren't really aware of the events that happened that morning, were you?
The morning of
July
his murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
If we have heard testimony from Dr. Baumgartner that Charles Vallow, when he was shot in the heart, would have taken up to a couple minutes to die after he was shot in the heart, and Lori Vallow has told Detective Enclan that she left right after Charles was shot, would that mean that Charles Vallow just lay dead on the floor for 45 minutes before Alex Cox called 911 at best?
Yes.
Fascinating. And so that's exactly what we were talking about, the way that prosecution used the witnesses, well over a dozen witnesses, to make their case and to set up conspiracy to commit murder. Now, we know that Daybell says she's still not going to testify. And like the former prosecutor said, is she believes that she's not going to do that because of the cross-examination issues or the concern with potential cross-examination there and the questions that she would have to answer to as well. But again, the word is flexibility here. All it takes is one juror today or tomorrow, whenever after they finish up all of their closing arguments and go into deliberations. You know, it takes one to have reasonable doubt at this point. So it might not be a clean and cut case. It might be something where we might see a different outcome here. But of course, time can only tell. The jury can only tell. And it is on the burden of proof falls on the prosecution here. So we'll see what happens there as well. And reminder, you guys, come back at noon, come out right before noon. We will be bringing in experts in this field. We'll be bringing in Rachel Smith, the former prosecutor up in Idaho. We're going to have a really good discussion over that lunch hour. So stay tuned. Just so you guys know, we're going to head over into the courtroom. They did have a few audio issues at the very beginning, but they got resolved in the first few minutes. But you can start to see what we've been talking about already for the past 30 minutes. Thank you so much for joining us, and we'll see you at noon.
All right, we're on the record, State of Arizona versus Lori Daybell, CR 2021-001704. Why don't I have the state announce? And the defendant?
Lori Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email. Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions, and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm to your students.
Anything else?
The presence of an accomplice.
Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from next defendant.
Okay. All right. So, how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Okay. And when is that going to be done, and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected.
All right.
The state redacted out the beginning, the end discussions of highway, have a figure say or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors in all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out. But it's just more or less what was played during testimony. Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know, it's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that. But the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions, so either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into, to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my
testimony.
advisory council checked the FTR, and that's exactly what was said. That's exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes, Your Honor.
Okay.
Full interview, the defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services, it doesn't include any of that. She's sitting in a room for, I don't know how long more Kylie's being interviewed, it doesn't include any of that. It is her interview about what happened.
Okay. So the state's closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview, and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that.
So, welcome back, everybody. So they're in a quick little 15-minute break, and we can kind of talk about what they have been talking about in the first parts of this. Oh, give me one second. We had our stream popping up. So looks like today Daybell will not be taking the stand as we discussed earlier. And we did say though that people predicted this, that even the former prosecutor in Idaho in those other cases said that she probably won't, and that it is a strategic move for her not to take the stand in order to avoid cross-examination. When it comes to Lori Daybell's kind of final stand here, she does have advisory counsel. So although she is acting as her own representation, she has advisory counsel. She said that that counsel went back into the records and found that at one point they said that the full interview was admitted into evidence, and that it was not. And so there was that back and forth between her saying, hey, if everything's going to be there, everything's going to be there, but it has to be struck from the record if someone said that everything would be there and there's not. Like we said earlier, it's that similar poking of holes trying to make that final doubt in there, and it only takes one juror to have that doubt. But it's her trying to do that before finally resting, and also before before closing arguments, which is her last say. And that's the only time that she's going to have left in this case in order to have her viewpoint and her case laid out. And without a full defense, since she's not bringing any defense forward, really, that is the only thing that she has, and that's what we're going to be seeing today after lunch. And we're hearing that it might be a shorter lunch than possible than previously explained, but we're going to have people coming in before, or during that lunch hour, before they come back and do those closing arguments, to break down what this could even look like. We know that the prosecution says it's going to take an hour or a little bit over an hour. I expect the prosecution to walk us through everything that we've seen, all 12 plus witnesses that came in. I think it was 13 witnesses, if I was counting correctly. But I think they're going to walk us through and restate the whole motive, and bring in that forensic evidence and try and paint the picture that it's sealed tight, when in reality, you know, Daybell is then going to come back and say that it's a conspiracy trial. And she has said before that she does not believe that the state presented enough evidence beyond a reasonable doubt that she truly conspired. And she still is saying, Daybell is still saying, it is a family tragedy. Whether or not she agreed with her brother's actions that day does not show forethought or planning into her fourth husband's death. But on the backside here, we know that the prosecution has been putting forward multiple motives, both religious and financial, and brought plenty of people to the stand to testify for that. I'm getting updates as well from Ashley Holden in the courtroom. So we know for sure that Daybell has rested her case. This is official. She had to do that in front of the jury. She tried to do that last week and then recanted and said, oh, give me till Monday. But she is stuck to her guns here in saying that this is what she's going to do. She's not going to take stand. She's not going to bring a witness. She's going to try and make that final testimony, her final case during closing arguments. And that's going to be really fascinating to see how that goes. I did sit down with Ben Taylor, who is a Phoenix attorney. He has plenty of experience in criminal cases and murder trials as well. And I spoke with him last week when things were kind of up in the air. Now we have a game plan, right? Now we know the game plan is, they're going to go into closing arguments, then jury instruction. Then we're going to wait and see how long it takes for the jury to come back after deliberations with a verdict. So now that we have the game plan, though, we're rewinding a little bit. I asked Ben Taylor specifically, what do you learn from a case like this? Right? She's already been convicted in another state. She's already serving 3 life sentences for this. Now we know that prosecution says that this is because of justice for Charles Vallow specifically, no matter what Daybell has already been convicted for and the sentences that she is currently and will be serving for the rest of her life. But if you're looking at a case like this, the question is, what should we learn from it? And I'll bring that up and see Ben Taylor's response.
I was a law student and you were teaching me about this case.
Yeah.
What would be your lesson to me?
Yeah, a couple of lessons here. First, never represent yourself. Always have an attorney represent you. Number two, one of the biggest things in law school, the first day in law school you learn, never ask a question that you don't know the answer to. In this case, Lori's asking a lot of questions that she has no idea what the answer is going to be, and witnesses are hurting her case because she's asking questions that she doesn't know the answer to.
And that has been a consistent thing, has been, we saw the last day of cross-examination. She was asking the detective with the Chandler Police Department, do you feel like you have done everything possible in order to come to your conclusions in this case? And he said, yes, we have done everything possible. She even said after that, are you sure? Really? Really have you? And those are the kinds of questions that, number one, have led to a lot of objections in the courtroom because she has not been doing law as a career. And so for her, she has brought a lot of questions forward that have had to be objected to, and those have been, for the most part, sustained. A lot of hearsay is kind of what the prosecution has been saying with those questions, and that can potentially hurt her in the eyes of the jury with the fact that she has been asking those questions that she doesn't necessarily know the answer to. Us and the journalism realm as well have that same kind of guardrail. It's like you want to be knowledgeable, but you want to also know what the person you're talking to might potentially say back in order to best ask the right questions here. And so with that case, those two things, number one, he said, don't represent yourself. He says that he also told me in another part of that interview that, we see people represent themselves all the time in court. However, we don't see it in a case of this profile, right? Of this level, a murder case, a murder conspiracy case. These kinds of things are not, it is very not typical to see the defendant represent themselves in this. If we're seeing somebody represent themselves maybe in a smaller court, different situations, things like that. And that's what makes this very interesting. And of course, seeing the back and forth that she's had with multiple witnesses. I brought up kind of a highlight reel of the past 2 weeks earlier, and we saw that back and forth with one of the women that went on a date with her fourth husband, Charles Vallow, the day before he passed. And she said, so you spent the whole date talking about me. And the witness was like, don't flatter yourself. Let's go back and we can actually play that whole thing. So you're going to see a bunch of different clips here, and they're going to be back to back. Might feel a little bit like, oh, what are we talking about now? Really, this is to give you a flavor of what the courtroom has looked like over the past 2 weeks. Why don't we play that and we'll come back.
Family tragedy is not a crime.
Lori and Alex knew exactly when this murder would happen and where it would happen.
Did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
All these things all added up into that moment and that morning. No doubt in my mind that they killed him.
Either the shooting did not happen that close in time to the 911 call, or that she wasn't there for the shooting.
It was probably Ned before we got rid of him.
Did you ask me what I meant in those text messages?
I couldn't.
Okay. So you spent your whole date getting to know each other, talking about me.
Don't flatter yourself. No, we did not spend the whole time talking about you.
And you weren't really aware of the events that happened that morning, were you?
The morning of his
July
murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
If we have heard testimony from Dr. Baumgartner that Charles Vallow when he was shot in the heart would have taken up to a couple minutes to die after he was shot in the heart. And Lori Vallow has told Detective Clan that she left right after Charles was shot. Would that mean that Charles Vallow just lay dead on the floor for 45 minutes before Alex Cox called 911 at best?
Yes.
You can see there all of the back and forth that has gone on between all of those witnesses to kind of break down a little bit of what you were looking at. You know, you saw Charles Vallow's sister take the stand, and she said, well, I didn't see you specifically one-on-one say I am conspiring to kill my brother, or, uh, my husband, but she says that all the evidence that has been brought forward, obviously both financial, you had the forensics, and then you also had the kind of motive type things on the religious side of things as well. She said that the evidence pointed towards it as well. Then you had Lori's other brother who took the stand to testify in this case. He said again, Lori asked that question, did you see me specifically conspire to kill? Conspire with Alex Cox to kill Charles Vallow? And he said, no, but he has no doubt in his mind. We'll see if that's enough, right, for a jury in order to come back with a verdict here, if those answers are enough and if that powerful testimony was enough. We saw that experts were breaking down those text messages, emails, all of that. You saw Ned, this kind of name that was given to Charles Vallow. A big part of this was that religious belief that Charles Vallow was corrupted in some way, or a dark spirit here. And we learned that from actually some friends in this community that she was in, that was saying they were worried about her. They were worried about her beliefs. They were worried about how it was shifting into this darker realm of things. She talked about Nephi, which in the Church of Latter-day Saints, represents a story of justified. This is what the prosecution says. The prosecution says that it would represent, in referencing Nephi in a text, a justified killing. Is that what the faith would believe? And the prosecution, in bringing those texts forward and bringing the Nephi thing and bringing Ned forward and those text messages, is trying to also set up a belief system and a kind of plan with those undercover words to show conspiracy. Same thing also with the financial aspects of things that the prosecution brought forward. They brought forward a life insurance agent who discussed when Vallow called, or Lori Daybell called their agency to say, hey, life insurance, he had $1 million policy. When can we get that? They said that, Charles Vallow actually shifted his beneficiary from her over to his sister, Kay Woodcock, at that time. So just to wrap up what we learned so far before we take you back into the courtroom, we've learned that Daybell has officially rested her case. Prosecution rested last week. Here's the game plan. The game plan is they're going to go back into court. They're going to have jury instruction at some point after closing arguments. And before that, there's going to be a lunch break. And during that lunch break, we're going to have an expert panel of analysts to talk about this, talk about what closing arguments might look like. And then we're on jury watch. So let's go back into the courtroom. Let's see what we're looking at now. And I will see you back at noon.
The defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. The jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof: 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
I'll have the parties back in the courtroom at around
Okay, everyone, thanks for joining us. You have been watching the stream of the Lori Daybell murder conspiracy trial here in Maricopa County. I'm Ashley Holden. We have Lillian Donahue, who has been doing a great job helping with our stream. We also have attorney Ben Taylor, and we want to get right to the biggest news that you probably just saw there. Obviously, you heard jury instructions read, but Lori Daybell is resting her case without calling any witnesses or presenting any evidence. So we saw prosecutors rest last week. We knew that Daybell had told the judge that she intended to rest today, but until today, we really didn't know if Daybell was going to take the stand and testify, change her mind, and no one knew in that courtroom until around 10:30 when she told the judge, and then 11 when she officially rested in front of a jury. So we have brought in some panelists, some guests, and one of those, like I said, is attorney Ben Taylor. And I want to get right to you. Obviously, we were all watching and waiting to see what she would decide. Are you surprised by the fact that she didn't take the stand? I've heard some people say that would have been a horrible idea.
Yes, I mean, it's for her to take the stand, she would have to be cross-examined by the prosecutor. And that means anything and everything could come up. So if Lori decided to say something that wasn't, correct, the prosecutor can open the door even about her kids. People right now, the jurors don't even know that her kids have been died and she's been convicted on that. So if she took the stand, that might have come up. So she was smart not to take the stand. However, the jury hasn't heard anything positive from her. She hasn't presented any witnesses. So what is the jury going to decide on? Her side of the story, which is nothing right now, versus all of the prosecution side. So right now she does have an uphill battle, but the fact that she didn't testify, that's a big deal. But I can see it both ways. Taking the stand, you're going to be cross-examined. If you don't take the stand, now what evidence do you have? So maybe she should have. Hindsight will tell, but we'll see in the future whether or not she should have taken the stand or not.
Yeah, and we want to remind people the focus of this trial. Lori Daybell is accused of conspiring to kill her fourth husband, Charles Vallow, but she does have another trial coming up. And if she had taken the stand, Ben, that what she said could have been used against her.
Yes, anytime you take the stand, you are under oath. So anything you say can and will be used against you. So the prosecutor can use her statements in this trial against her next trial. So it's very tricky whether or not you should take the stand. I kind of believe that she should have taken the stand in order to present evidence, because if you don't present evidence, the jurors are just sitting there wondering, wait, we heard from all these witnesses from the prosecution, and now it's your turn, Lori Daybell, and you haven't said one word or presented one witness. So that's going to be very confusing to the jury. The jury's like, wait, all these massive witnesses that we heard from the prosecution for the past couple weeks, and now it's your turn, Lori Daybell, to take the stand or to present evidence, and you decided to rest your case. So jurors, they look at that, they see the number of witnesses, they hear the number of evidence, and they're gonna be wondering, why in the world did she not say anything throughout this whole trial?
Yeah. So what's going to happen next? We want to remind people that closing arguments, originally we were told by the judge, would start at around 1. We are on a shorter lunch break. So jurors have been told to return to the courtroom at 12:45. Parties, so Daybell and the prosecution, have been asked to return around 12:40. Ben, you're very experienced. What is it like to prepare a closing argument, and what are you expecting from Lori Daybell's closing arguments?
I've done murder trials, I've had conspiracy cases, and these are high profile cases. So during the lunch hour, you're just getting all your notes together. Sometimes as an attorney, you don't even eat lunch because you're so nervous about being able to say the right words in front of the jury. Because at the end of the day, those 12 jurors are going to be the ones who decide whether or not Lori Daybell is innocent or guilty. So right now, the prosecutor and Lori Daybell are writing notes down. They're preparing their closing arguments, and they're hoping to convince, the prosecution is hoping to convince all 12 jurors, it has to be unanimous, of a guilty verdict. Lori Daybell, like I said, she's an uphill battle, but she's hoping that 1 or 2 jurors will be on her side to maybe even get a hung jury. To get all 12 jurors on her side, I think is going to be almost nearly impossible based upon this evidence. But if she can convince 1 juror or even 2 jurors to go back in there in the jury room to argue on her behalf, to help her, you know what? This is really confusing. There's no main evidence to show that she actually did conspire to kill her ex-husband. Maybe she is innocent. I can't decide. So hung jury. So that's what Lori Daybell is hoping today.
And I want you to talk us through jury questions. Jury questions you were talking to me about, and I think this is something that people, so if you're watching from another state like Idaho, I had a lot of fascination with the fact that jurors here in Arizona could ask questions. We heard the judge talk a little bit about this, and he said that during this process, if they had a question and they wanted to get a message to the judge, that they would actually fill out a jury written form. So can you kind of describe what that process is like as they go through those deliberations?
Yes. So once closing arguments are done, the jurors go back into the jury room and they sit down, they pick a 4-person. And the 4-person and the jury will decide how long will they deliberate for, their schedule. And basically they sit down and they discuss all the facts and the evidence. If there's a question that comes up they're confused about, they can write a note to the judge. The judge then gets the note. The judge then calls the attorneys back in, which is Lori Daybell and Trina Kay, the prosecutor, and they all sit down and discuss this juror question. If it's an appropriate question to answer, they will write a note back. The judge will write a note back to the jury and answer the question. If it's a question that's not relevant or maybe evidence was precluded so they couldn't come in, then the judge would say, I can't answer that question, or please refer back to your jury instructions for further information. So of course, we're probably going to see at least one or two jury instructions or jury questions throughout this trial, because even though there's a lot of evidence, it's confusing. Text messages, body camera, forensic science evidence. So jurors usually have at least one or two questions. So don't be surprised if questions do come up and then the judge decides to answer it or not answer it.
And Ben, we know that closing arguments are next. And we've talked before that it's not unusual for somebody to represent themselves, but it's very unusual for somebody to represent themselves at this level in a courtroom and at this with these types of charges. How would you analyze Lori Daybell's representation of herself? Has she done enough to create that kind of question mark in one or two juries' minds, in your opinion?
Not right now. Her cross-examination has been okay at best. Okay at best, meaning that it hasn't been that great. But closing arguments is when you can hit a home run, and that's the last thing the jurors will hear from her mouth is Lori Daybell's words. The only bad thing that she has in closing arguments is that the prosecutor gets two bites at the apple. They will start, Lori Daybell will speak, and then the prosecutor can go up to the jurors and pretty much cross-examine or rebut anything that Lori Daybell has to say. So she needs to look those jurors in the eye and convince some of those jurors to be on her side. And that's going to be very hard because, I mean, throughout this evidence, there's tons of evidence against her. But if the jurors like her, one or two, and they really believe her in her closing arguments, who knows what might happen in this case.
And talking at the prosecution side, flipping the whole question around, prosecution brought financial motives, religious motives forward, with a lot of evidence, like you said, those text messages, emails, video evidence, even down to cell phone pings. Do you feel like that painted enough of a picture to show conspiracy, though? Because without that text message, saying, oh, we're going to do this today or whatnot, it's not really a smoking gun yet.
Yes. A lot of the evidence is what you mean indirect evidence. Indirect evidence is like evidence you have to kind of put together, piece together. Direct evidence is what you actually see or heard on a camera or a witness has seen or heard. So Trina K, the prosecutor, does have a little bit of a trickiness there to be able to get a straight conviction. This is not a totally easy trial. Even though there's a lot of evidence there, as you heard, Lori Daybell, one of the things she said is, have you seen me do this? Have you heard me do this? She asked multiple witnesses that question. A lot of witnesses said, no, we haven't seen you or heard you do that. So if she can convince some of the jurors that, wait, I didn't hear any of the witnesses said that she saw or they heard her do this, maybe you might have one or two jurors who's like, hey, I can't decide, and she might get a hung jury.
Ben, as someone who has done criminal defense throughout your time, how much, obviously, Lori Daybell, this is the first time she's representing herself. So she might not be doing this, but as an attorney or a prosecutor, how closely are you watching the jury and what they are focused on? And do you think that came into play when the prosecution decided to rest their case?
Of course. When the jurors are the ones who decide the case. So throughout the trial, as a defense attorney, as a prosecutor, you're always paying attention to the jurors' questions and then their mannerism. Are they paying attention to you? Are they slouched? Are they crying of emotional testimony? So you're watching each and every juror, and all the jurors have numbers. So when a juror writes a question, you know exactly which juror writes it because they're numbered. If juror number 5 writes a question, juror number 10 writes a question, well, juror number 10 is on my side or maybe against me based upon the question. So the prosecution or Lori Daybell, they might feel pretty confident based upon the jurors' reactions inside the courtroom.
I want to go back a little bit through the witnesses that we saw. We saw former friends, we saw family, we saw law enforcement, but we ended on that last day with the lead detective on the case currently for Chandler. We saw those text messages. When you're laying out a case as a prosecutor or an attorney, do you think about every tiny thing as to what is going to be my last person on the stand? Because you must be thinking, I want the jury to receive this information last. Is that right?
Yes, Ashley, that's 100% right. The prosecutor has already had their witnesses laid out right there. She knows exactly who to call and who not to call and what day and which order. Only time you might switch up a witness if some surprise evidence comes up or a witness gets sick and you can't call them because emergency comes up. But most likely, you want to start out strong because you want to wake the jury up and have a strong witness at the very beginning. And the last witness, like you said, the Chandler detective, that was the witness that the prosecutor wants to hit the home run because that's the last witness the jurors will hear before the prosecution rests. So that's why they call a strong witness at the very end so the juror can hear the last words of a strong witness.
Thanks, Ben. So when I've been looking at some of this throughout the whole trial, there's been kind of this contentious back and forth. There's been a lot of hearsay. And why don't you talk about this, right? So when Lori is asking questions, when she was cross-examining, there was with those objections for those who don't necessarily know why can't she say that in court? Like, what were some of the biggest issues with that examination that you were able to witness while watching this case? And could that potentially hurt her?
Yes, a lot of times when you're a defense attorney, you could interview witnesses prior to even taking the stand. It looks like that Lori Daybell might not have even interviewed some of these witnesses, might not have prepared for these witnesses. I almost feel like she was writing some of her cross-examination questions on the fly. She was hoping and praying that the correct answer would be for her favor. And a lot of the witnesses were just hammering her because she didn't really know what answer was going to come out when she asked the question. And that's like law school 101, knowing what the answer is going to be, or at least assuming or kind of leaning towards knowing what the answer is going to be. So a lot of the witnesses did hurt her throughout this case, and we'll see what happens in closing argument. I mean, she has to come out and hit a home run in this closing argument to have any sort of a chance to be able to get a not guilty or even a hung jury.
And then looking at the prosecution side of things, you said it is not a clean and cut. It's not a smoking gun yet at this point. They still have some work to do on their end. What would you say is the most powerful either testimony or evidence that was brought forward by the prosecution so far over the past 2 weeks?
I think the body camera evidence, that was powerful. The fact that they had the insurance adjuster take the stand and testify that Charles pretty much had to call and change the benefactor on his life insurance policy, that shows strong evidence. And the fact that Lori Daybell was very nonchalant. You watch the body camera video, you don't see her showing remorse. You would think that your husband had just been killed. No matter, even if it's in self-defense, you would be crying, you would be sad. So I think what's going to maybe dig her grave in is the fact that she didn't really show any remorse when they showed the body camera video.
I thought it was interesting. I've talked to the special prosecutor who worked on Daybell's Idaho cases. And one thing she said was, even though Lori hasn't put on any witnesses or put on any evidence, she did somehow kind of slide in some ideas during her cross-examination that Tylee, her daughter, had a contentious relationship with Charles Vallow, her stepfather, that possibly Charles Vallow, she even at one point, kind of seemed to imply, could a drug test come back showing if he had been taking other things like testosterone or something like that. She's tried to slide in these ideas throughout court. Now, that's not to say, Rachel Smith didn't think that this was going to be convincing to the jury. What do you think? Do you think the jury is going to pick up on that? Or do you think that that's hard for a jury to kind of understand?
That's the thing. I mean, the prosecution doesn't have this in the bag yet, right? And they had to convince all 12 jurors. That means unanimous jury. So you have to make sure that all 12 jurors are understanding everything. And we've been here for a couple of weeks now, and this evidence is confusing for some of the evidence, right? Some of the forensic evidence. So all it takes is one or two jurors to be like, I'm confused here. I have no idea what's going on. I mean, a lot of people are saying this is easy cut trial, and it is. It really is. However, all it takes is some jurors to be confused and not understand some of the evidence and show doubt. That's why they say beyond a reasonable doubt. If Lori Vallow, during her cross-examination, was able to put some doubt in one or two jurors' heads, who knows what might happen.
Yeah. Let's talk about deliberations. You know, we're going to have closing arguments, and then we heard from the judge that the jurors were going to decide their own deliberation schedule with the approval from the courts. So, as an attorney who's gone through this, what is that like to be waiting to have these deliberations happening? I mean, are you just on pins and needles?
Yeah. I mean, your gut is just turning, your heart is like racing. You're on pins and needles because you know the jurors are the ones who decide the case, and you have no idea what happens until you walk back into the courtroom. You sit down. The judge doesn't know. The prosecutor, Lori Daybell, nobody knows what's going to happen to regards to the verdict until they read the verdict in open court. So you're nervous. You have no idea. But when the jurors do ask the questions, you kind of can tell which way they're leaning towards, depending upon how the question goes and whether or not they ask more questions. Because so this type of case, you might get a quick verdict, or if we see this go past today or tomorrow or even into Wednesday, you know that somebody in the jury room, they're discussing something. Because if they were unanimous, they would be done. But if it's the longer it goes, that means they're confused about something or they have more questions.
Ben Taylor, thank you so much for joining us. We're going to bring in our other guest and let you go. We really appreciate everything that you've been able to do and your legal expertise that you've been able to shed on this case. We want to remind everyone we are talking about the Lori Daybell murder conspiracy trial that is happening. Closing arguments are really going to start here in almost 30 minutes. We want to bring in Dwayne Cates, who we have talked to before here at ABC 15 as we cover some high profile cases. Thank you so much, Dwayne, for coming on with us. We've got closing arguments, like I said, happening in around 30 to 40 minutes. As an experienced attorney here in the Valley, what do you feel as you're planning your closing arguments or those minutes just before you deliver them?
Well, just like Ben said, your stomach's, your stomach's in a knot. And if it's not, you don't care enough. So, but you got to be, you're on pins and needles, but usually it's not so bad before closing arguments because you're spending your time preparing. Okay. And you're making sure that you have it all done. In fact, you may even be at home rehearsing or in a back room somewhere rehearsing what you're going to say. Because sometimes when you plan to say something and then when you say it out loud, it sounds different. So you want to kind of say it out loud before you get in front of a jury. But there's no greater feeling than closing arguments. It's my favorite part of trial. I mean, anytime I can dress up in a suit and get in front of people and talk, I'm happy.
Yeah. What do you think, Dwayne, we're going to see from prosecutors as they kind of try to seal this case up, as they hope to get a conviction in this case?
Well, I know this prosecutor, and she's really good. She is going to just be matter of fact. I don't think there's going to be any dramatics or theatrics. She's going to be very matter of fact. She's going to say, let's look at the evidence, and she's going to organize it in a logical way that hopefully she can have it make sense to the jury about why this is going on. And by this point in trial, she knows what all the you always have problems in your case. She knows what the problems are. She knows what, and she's coming up with ways to matter of factly state what's going to happen and what happened and what the jury should do.
Dwayne, thank you for joining. I want to ask, we were expecting a 6-week trial. We were expecting a lot more. Granted, there were over a dozen witnesses in this case. So we know that the prosecution presented a lot of evidence from a bunch of different kind of spokes in their argument. But the fact that we're only 2 weeks and 1 day in, what does that say about this? Does this say that the prosecution feels really confident? Is this just kind of a byproduct of Daybell not bringing anything forward?
Well, it's part of her not bringing anything forward, but there's always 3 trials. There's the one you plan, the one you do, and the one you wish you'd have done later. So you never really know how long things are going to take. And a lot of times when you have a non-attorney as one of the the litigants in the case, then see they're not going to make nearly as many as objections. There's not going to be as many sidebars. There's not going to be stoppages to fix things. So that's the case. That's one part of it. And also, I always think less is more at trial. Some prosecutors want to go on and on and on about things that have really no bearing on the trial, just because they don't want at the end of the day to think they missed something. But you do that at the risk of boring jurors, and you don't want to bore the jury. My philosophy at trial is to get in, be entertaining, capture their attention. When I stand up to talk, I want the jury to go, "Oh, good, it's that guy." Not, "Oh God, it's that guy going to get up again." So I want them to be excited about what I have to say. So I try not to, I like to say I don't leave any dead horses in the courtroom. I'm not beating dead horses all day, just, making points over and over and over again. I try to make the points clearly, one time, two times, and then talk about it in closing, and get through the trial. And I think that the jurors, you're more likely to persuade jurors when they like you. So, and I think that's part of it.
And you said you were excited for closing arguments.
Oh yeah.
How might that differ from the introductory statements that we saw 2 weeks ago?
Well, I like opening statements too. I mean, I like anytime I get to give a speech, but opening is a little more calculated,
Mhm.
okay? Because in closing, you can only argue the things that came in as evidence during the trial. And in opening statement, you can preview the evidence, but you can pretty much get away with saying whatever you want as long as you start with the evidence will show, okay? And very rarely does anybody object. But but opening statements are a little bit different. And again, there's more nerves for me in opening statements because it's the very beginning. It's the first time I get up, okay? And first impressions mean a lot, and adrenaline is pumping. And if you don't, that's why I move around a lot, because I really I want to dissipate as much adrenaline as I can. And I try to channel it into my diaphragm, into my voice, into my speaking, and not because adrenaline will make you freeze. Adrenaline will shut your brain off if you're not careful. And, and you got to be really careful with that.
Yeah. And we want to let everyone know. So where I am standing, I'm outside the Maricopa County Superior Courthouse, and I'm going to have to go here in just a few minutes. Lillian is going to take over the stream. We have another guest who is joining after Dwayne. We have the parties who have been told to be back in the courtroom at 12:40, the jurors who have been told to be ready and back up in their spot by 12:45. Closing arguments will begin, and then this will be in the hands of the jury. But I do want to ask you, Dwayne, I've had some people tell me, and this has been a question that has come up, do you think Daybell not calling any witnesses, not presenting any evidence, was a strategy to put the burden of proof on prosecutors? Or do you think she was having a hard time, we know, serving potential witnesses, finding potential witnesses? So do you think this comes down to strategy, or do you think this comes down to Lori Daybell is defending herself?
Well, it's probably a little. It's probably a little of both. Okay, she probably is having trouble subpoenaing people because she's in custody now. I'm sure they gave her an advisory attorney to help with things like that. But again, also, she can't testify in this case, because if she testifies in the case, the fact of her prior convictions comes in. So she can't testify, and so we're at that point where what does she have that she can bring on that's really going to move the needle at all? And there are a lot of cases where I don't call a witness. Okay, I mean, it's all about whether or not they can prove their case. And sometimes your witnesses hurt you. If you don't prepare them correctly and know what you're doing in on direct examination and on cross examination, I mean, they can melt down and they can kill your case. So it's always a little bit of a wild card calling witnesses, especially if they're just tangential witnesses that really don't have anything to do, with what's going on. Then you're way better off just resting.
Thanks, Dwayne. And so, when we talked to Ben earlier, I asked him this question: what would I learn from this case? It's not typical for somebody to be representing themselves in a murder conspiracy trial. What do you think viewers of this should take away, no matter the verdict?
Well, one thing I tell people all the time, and I just told a client this just a little while ago in my office, is that there's only really two reasons to go to trial. If you think you can win or if you got nothing to lose. Okay, she's got nothing to lose. She's doing life in prison. Why not get up in front of a jury and put a show on? I watched bits and pieces. I didn't watch a lot of it because I was busy, but I did watch pieces of it, and it looked like she didn't do a horrible job of it. She's attractive. She's fairly well spoken, and she may garner some sympathy by getting up there and doing that. So she's got nothing to lose. So why not? Why not do your best?
Yeah, and as much as people say it's a clean cut case here, without that specific smoking gun evidence, proving conspiracy and showing conspiracy. And granted, the evidence against her is quite strong. They had 2 weeks full of evidence and multiple different areas. Do you still feel though that there is a chance that the jury could come back hung or even not guilty?
Well, two things on that. Number one, life works on a bell curve. So out of 10 trials, you're going to win one you're supposed to lose. You're going to lose one you're supposed to win, and the other 8 turn out kind of how you have it figured. Okay. Another thing is because it's a conspiracy trial, I won a conspiracy trial, and I told the jury that my client could be walking down the street with a bale of marijuana under each arm and not be guilty for conspiracy to commit possession of marijuana, because conspiracy is about an agreement. Okay, that the prosecution has to prove that she had an agreement with the guy to kill him, not that she wanted him to kill him or anything else. There had to be a specific agreement that she wanted him to do it, between the two of them. Okay, she could make an agreement with somebody else. That's not the conspiracy. There has to be an agreement for him to do this. Okay, and so I mean that's lost a lot of times, and she probably won't mention that in her closing arguments because that's what I would be saying. They have to prove that we had an agreement. Where's the proof that we had an agreement, that there was an agreement between us?
Yeah. And honestly, you moved right into my next thing is what would Daybell have to say in those closing arguments? I think for you, you're saying Daybell would have to truly lean on that. Hey, this is a conspiracy to commit murder case. And this is was there premeditation? Was there a discussion with Alex Cox? There was a lot of tap dancing around with, hey, here's this text that references Nephi, or here's this text that references Ned, who they thought was, it was a code name for Vallow, who had a bad spirit with him. So there's just a lot of different things that could point to it. But she asked every single witness that she had with her, or not every single, but multiple witnesses, did you physically see me have any kind of conspiracy? And they said, I think her brother said, no, but I have no doubt in my mind. The sister of Charles Vallow said, no, but all the evidence points towards it. So it's interesting to know if the prosecution has enough. And for you, as somebody who's gone into closing arguments, do you think that there's a good amount of pressure on prosecution right now? And what would they have to do to put the cat in the bag?
They're going to have to say, that this is a conspiracy case. Okay. And here's the 10 things that came out as evidence that say that there was an agreement between her and Alex to kill him. I mean, that's what they have to do. They have, she has to say, okay, when she said this, that's a sign that she was asking him to kill him. Now, there has to be an agreement, and that, the premeditated. I mean, the murder was premeditated. Okay, the question was there an agreement between Lori and Alex to kill him? That's the question. If there was an agreement, she didn't have to do anything. She could have been in another state. She could have been in Alaska. Okay. And it would have made absolutely no difference. But that's the key to a conspiracy case. And I don't know that she's astute enough to hammer that home to the jury that this isn't about whether or not this was a first degree murder case. It was. The question is, did we have an agreement? Did I make an agreement with him to do that? And did I help him in any step of the process? And that's conspiracy.
And I think that's a very good distinction to make. And I appreciate you helping us kind of walk through that distinction, because that is the exact question that the jury is going to have to have. We, after closing statements, will be on verdict watch for however long this could take. In your experience, do these kinds of cases have a longer jury deliberation time, or is it pretty quick?
I've had juries come back before I can get to the cafeteria. Okay. And I've had juries out 6 days. Okay. And you don't know what you don't know. I mean, when I was in law school, I was on a jury, and we went back to the deliberating room, and they made me foreman. And then they said, okay, I said, well, let's take a straw vote, see where everybody else guilty, not guilty. And it was like 5 guilty, 3 not guilty. And one of the jurors goes, oh, that's reasonable doubt. We can go home now. And I'm like, well, no, that doesn't how it works. Okay. So you don't know what's going on in that back room. I mean, I did a case on Dateline NBC that I thought was absolutely a not guilty case. I eventually got the verdict thrown out, but they
Mhm.
were out like 3 or 4 days, and they came back guilty, and it shocked everybody in the courtroom, including the judge. Okay. So you don't know. You get one juror back there, especially if it's the foreman, that's strong, that's a really strong personality that advocates for one side of the equation. Okay. And you can get some strange results. That's where I say the 10 trials thing. There's some you just shake your head. I mean, I've won trials before I walked out and going, wow, I don't know what they looked at, but I'm glad they did. Because again, you just don't know. You don't know what they're doing.
Yeah. Was taking the stand just too risky for Daybell at this point?
Well, absolutely. She can't take the stand. If she
Yeah.
takes the stand, then her prior convictions become relevant, okay, as to her credibility. And they would get in. They may not get in exactly what they were for, but they would get in that she's been convicted of several other felonies. And again, most jurors, when they hear that, especially when they hear a witness has a bunch of felonies, they tend to believe them less. But when the defendant themselves gets up there and it's found that they have a bunch of felonies, then that's a problem.
And we've seen this many times throughout the case so far. It's just been objection after objection after objection, hearsay after hearsay, and things like that. Do you feel like there might be that similar pattern in closing argument? I mean, at what point would she cross the line into giving her own testimony without facing cross examination in a closing argument?
Well, and that's a really tricky line. Okay. Generally speaking, judges and opposing counsel give the other side quite a bit of leeway in closing arguments. Now, closing arguments are limited to the evidence that was presented at trial and reasonable inferences drawn from the evidence. So it's not just strictly the evidence. You can draw inferences about what this piece of evidence means. You get to talk about that. Okay. And so she's going to have quite a bit of leeway in this, but you just don't know, you know, vouching is a really big thing in closing arguments where, but again, it's she's the defendant. So, because it's not proper for the prosecution to say, I believe 100% that she's guilty, because now you're putting the force of the state, state's belief, and what the prosecutor believes is totally irrelevant to anything. Now, what Lori Daybell says, because she's the defendant, could be different. I mean, because it is relevant to what's going on. And she could say, I didn't do this. Okay, now that wouldn't be vouching, because that it's her case to try. She's going to look at the evidence. The evidence shows that I didn't do this. Okay. And you got to allow her to do that, but there's going to be some tricky spots. And Judge Bresky's been on the bench for quite a while, and he's he knows the rules of evidence, and so I don't always agree with him, but he'll keep it in check if there's a problem.
What do you think has been the hardest thing for Daybell? Has it just been figuring out how to represent herself as if she is an attorney?
Well, the hardest thing for self-represented people is they don't understand that why I can't bring this up, why I can't put this piece of evidence in. They don't understand foundation. They don't understand the rules of evidence are pretty tricky. Now, judges, even though they say they're holding them to the same standard as an attorney, generally cut pro per some slack, okay, in that. But again, they can't, they don't understand. I tell people all the time, the trials are like a jury's looking through a toilet paper roll, right? All they see is what's inside the middle. They don't get to see all this stuff that's going on out here. And the rules of evidence governs what you could put in this picture frame for them to look at. Okay. And a lot of times people say, well, that's not fair because all this other stuff's important and would affect a decision. But that they try to keep it to the proving that somebody's a really, really bad person, okay, uh, doesn't mean that they committed this specific crime. So they try to keep that kind of evidence out. And so it's really hard. It's really hard for a layperson to understand, well, why can't we talk about that? Why can't I bring that in? And that's and I've seen pro pers get really, really frustrated by that.
And actually, so fascinating you bring that up because I don't know if you've been watching this morning specifically. She brought up an issue with the interview that was entered as evidence. So her interview with the detective, the evidence, where they were basically trying to show how nonchalant she was. They were trying to show discrepancies based on what she told them on the scene versus what she told them later. And she said that someone said in the courtroom that it was the full interview that was entered in for evidence. She said her supporting counsel told her that that was not true and that it was only a portion, and so there was a discrepancy there. Seems like the judge said that she could have addressed this when they examined the witness. But do you feel like at this point it's kind of it was like a last ditch effort to say, hey, I want that whole interview in there. I want the jurors to see all however many hours I talked to that person for.
Well, that's something that should have been hammered out ahead of time. And it's one of my pet peeves at trial
Hmm.
is if you have a full interview and they clip out a 3-minute segment to play to the jury, okay, and they don't provide that to me ahead of time, okay, I object because and it is true that by taking a piece of the evidence out and putting it in a separate video clip, they've created a new piece of evidence. And I have the right to examine that. I have the right to check to see if it's been altered by AI, anything else. And the prosecutor's argument is, well, he has the full clip. I mean, why do I have to provide him with the piece that I took out? I go, well, I want to see how you cut it. I want to see where it stops, where it starts. I need to know all that before trial. And that's one of my big deals. And so, if if they if they didn't put the entire clip into the entire interview in as evidence and her attorney told her that they did, okay, that's going to be an appellate issue. Okay, it's probably not going to win the day because again they there's a thing in appellate that basically no matter what you even if they'd have done that you would have lost anyway, so we're not going to deal with it. But that would be something that will come up on appeal if there's an appeal in this case.
So it kind of sounds like there was sort of her trying to set up some sort of not just doubt in jury's mind, but also a grounds potentially to come back. Should
Did she do that in front of the jury?
Yeah, she did that in front of the jury, and she said, "Well, someone said here in the courtroom that it was the full." I think she was saying the prosecution said it was the full interview when
Oh,
only a small portion was clipped and sent into evidence. He did say that the judge also did say that any other aspects that have been considered hearsay have been redacted from that evidence. But so it's interesting, and it does sound like and point to that she could be setting herself up to come back.
Well, sure,
Should something happen,
as
obviously.
any good attorney would.
You're right. Right. And so she's definitely
And if she
doing what
doesn't
she can.
complain about it, if she doesn't complain about it on the record, then it can't be brought up on appeal. So the fact that she brought it up is, is part of what she should be doing.
So, for her representing herself, it wasn't a total failure at this point. She's actually brought up some decent things
Yeah.
here. It seems like she has listened to counsel in some way. It's just that it's a difficult situation that she is
Oh, it
in.
is.
Yeah. We know that she also tried to subpoena next of kin without notifying the state. And I know that that was an issue earlier as well. And she didn't bring any witnesses forward for this. What I think, kind of to wrap, what do you think is the biggest thing that she or the biggest thing that she needs to bring forward, aside from, hey, this is conspiracy? Does she need to clarify things? Does she
Well, she
need
can.
to
She
yeah.
can take bad things that are bad for her and explain the bad things. I mean, and that's kind of what you need to do in closing is the state said this and the state said that, but that's not exactly what happened. And there's other evidence that says it different. So she needs to do a lot of that. What she's got to do is she's got to win the jury over personally. Okay. Okay. She needs to be very likable and friendly and sympathetic. And if she can do that, then she's got a chance at a hung jury. You only need one juror. So like if she can talk to one juror specifically, and win that juror over, then and I've kind of been known to do that in closings, is talk to one juror, one that
Mhm.
I know that's kind of been with me the whole time, and try to get them to, and tell them things like, hey, you know what, when you guys go back there and you're deliberating on this, okay, don't give up your position easily. If you have a position, unless somebody thoroughly convinces you that you're wrong, don't give up your position, because it's your right to have that position, you know. And
Mm.
so I get objections sometimes because I'm arguing for a hung jury, basically. But that's what it is. You get to talk to people. It's one of the few times in a trial you get to look the jurors in the eye. You get to walk up like relatively close to them. You get to look them in the eye. You get to talk directly to people. Okay, and so you need to do that. You need to win some over. And then sometimes you try to win over the ones that don't like you.
And your experience with looking into, obviously, the conspiracy to commit murder cases, has this followed? I know you haven't been able to see everything, but has this followed kind of the same format that you've seen before? I mean, how common is it for somebody to even represent themselves at this point?
Well, it's not very common at all for people to represent themselves in a homicide case. And again, she's doing it because she has nothing to lose. Okay. I mean,
Mhm.
that's the bottom line. Most conspiracy cases, conspiracy to commit murder cases, there are text messages or something saying, hey, I want you to kill X, I want you to kill so and so. They may not say it exactly explicitly, but they may say, so and so's got to be gone. You got to make him go away. You got to, they use code words and stuff, and maybe even code names. But usually, in today's day and age, it's text messages that get most people in trouble. And in a conspiracy case, it's really important, because you're having to prove an agreement, is to find an agreement somewhere in text messages or emails or something.
And I think the closest things that they were able to try and find that agreement, and I think that they're going to argue this afternoon. The prosecution's going to argue this, is some of those text messages where they're referencing Ned, which is the alter ego, or for lack of a better term, like it's Charles Vallow, but corrupted Charles Vallow, possessed Charles Vallow, talking about Ned leaving. They talked about in those as well, those text messages that Lori texted and said, I need you to stay close in the next few days. Almost like she knew something was going to happen, but she never flat out said what was going to happen in those
Right.
text messages.
Everybody thinks this is a slam dunk case, but I think if it's handled correctly, I don't think it's that big of a slam dunk. I could be wrong. Like I said, I didn't see all the evidence. In
Yep.
trials, unless you're very skillful at directing juries, trials are about what they look like, not about what they are. It's not about what really happened. It's about what it looks like happened through the lens of the prosecutor's case. Okay. And so, again, without a clear, agreement, they may prove beyond a reasonable doubt that she wanted him dead. Okay. And,
Yeah.
and find her not guilty. But see, unless she knows how to tell them to do that, okay, they may not know that that's what they have to do. Like in Vordaer, in that case that I won, I said, I made the jurors promise me. I said, would you follow the law even if you didn't like the result that it produced? Okay.
Mm.
And they all said, the ones that didn't say yes, I got rid of. Okay. But, and you got to make them agree to follow the law. And then you got to say, here's the law. There's got to be an agreement. Show me the agreement.
Yeah. Thank you so much, Dwayne. I appreciate you. Thank you for your analysis. I'm sure we'll lean on you in the future.
Sure, anytime.
And yep,
And
thank
next
you so
time
much.
I'll remember to turn my light on. So
No, you look great. You
I'm
look
not
great.
so
Well,
much in the shadows.
no, you're awesome. Well, thank you so much. It'll be fascinating to kind of catch back up with you after a verdict and all that stuff. So we want to bring in our next analyst here, the talented Rachel Smith. Rachel, you were in the Idaho case. She already has 3 convictions, and you were the special prosecutor in that. So right now, where we're sitting right now is they are going into those closing arguments, closing statements, and then we're on jury watch, and we're going to see, or verdict watch, see how long it takes. Bring me back to the time when you were in Idaho. What are you thinking before you're walking up and making those closing arguments? What is going through your mind, and what's your game plan?
Well, Rob Wood on the team did the closing arguments. So as the parties the night before were going over final arguments, we were really keyed into what did the jury see? How did the jury react? What holes do we think are out there? And so we learned very quickly from the jury's reaction to the physical evidence, the autopsy pictures and the graveside pictures of JJ, the pictures of Tylee's remains, the autopsy pictures of Tammy. We could tell from their reaction, one, they understood it. 2, it was just excessively difficult for them to see. And we walked into it knowing they got that somebody did horrible things to these children and to Tammy. And so in closing, we chatted about that. How much do we talk about the physical evidence? So as a prosecutor, you're keyed into what does the jury seem like they're understanding? What are they looking at? What are they paying attention to? You got to know your jurors. And so for us, there was some time spent on the manner of these people's deaths, JJ's death, Tylee's death, Tammy's death. But there was really more time spent on Lori's role in leading this situation. Lori's manipulation of Chad, Lori's manipulation of Alex, Lori's manipulation of others for the overall conspiracy. So what a prosecutor does is you pay attention to your jury. You pay attention to how your evidence came in, and you focus your arguments based on what a jury wants to hear. So here in Arizona, they're gonna understand how Charles died. The physical evidence is pretty darn clear. It's not self-defense. There was no need for a second shot. Charles was already down, and the angle and the entry wounds and the exit wounds in Charles show he was already down. That second shot was not in any way arguably self-defense. So the state will talk about that. They'll go over that to some extent, but then they're really going to focus on Lori's role, Lori's manipulation of Alex, Lori's efforts and desires and furtherance of the conspiracy. And I suspect you're going to hear sort of what I call the but for argument. But for the action and the conspiracy by Lori Vallow, would Charles Vallow be dead? And that's what I think we're going to see the prosecutor really focus on. What that jury is going to want to know is, would my wife, would a mother let somebody do this in front of her children to kill her husband, soon to be ex-husband?
And
And
we've
they're
been
going to tell him
talking,
how.
yeah, I mean, the but for, we've been talking about this all lunch hour, is that it just takes one. It just takes one juror to have that question in the back of the mind. And this is a conspiracy to commit murder. So the prosecution has to show that there was an agreement, just like Dwayne just said, that there was that agreement between her and her brother to make this happen. In looking at some of the evidence that we saw, especially those text messages, they referenced Ned, they referenced Nephi, but there isn't that exact text saying, all right, we are going to do this at this time, and this is how you're going to make it look like it was self-defense. Do you feel like the prosecution has done enough then to try and point all arrows toward conspiracy?
They have, and you can tell they really focused on it because that's how they started, right? What were Trina K's opening words? I'm gonna need you to stay close to me. It comes ahead this week. I've been told I'm gonna be like Nephi, and so are you. So Trina started out and tried to frame the evidence at the very beginning from the evidence of conspiracy and from Lori's leadership in that conspiracy. That wasn't a text from Alex to Lori. That was from Lori to Alex. Lori's the one saying it's coming to a head this week. Lori's the one saying near to me. Lori's the one saying she will be like Nephi, and so will you. So the prosecutor started that framework in her opening statement, and they've carried it all the way through. It's been pretty clear that the focus has been on Lori's communication, Lori's conduct, Lori's attitude and demeanor after Charles is dead, Lori's motive for the insurance. So you can see her role, and this is the prosecution systematically showing that but for the conduct of Lori Vallow, she was Vallow at the time, but for Lori Vallow's conduct, Charles Vallow would be alive.
Interesting. And so we have just heard from Ashley Holden, who you've been speaking with. She's in the court right now. We know that we have that 30-minute delay. So we're going to keep talking about this before we are able to see specifically what's going on. But she just let us know that closing arguments have already begun.
Okay.
What is in the mind of the prosecution as they're talking? We know the prosecution said that their closing arguments are going to be an hour. I mean, what's in the brain here?
What's in the brain is you're worried about those one or two jurors. Sometimes I call them sleepers, that really don't like circumstantial evidence and worry about conspiracy. Circumstantial evidence are those cases where there isn't that, hey, go kill Charles statement, or where there's pieces you have to connect that show the person's doubt. And some jurors struggle with that. And then you're focused on connecting those dots for any of those jurors that struggle with that idea. And you're focused on explaining the law and explaining the evidence to the jury in a way that makes sense to them, that is persuasive, that helps them see the answer that you need them to see, is that but for Lori Vallow, Charles Vallow would be alive. So as you're going into it, you're going to start with sort of a summary of this is the evidence. And this is how and why Lori deserves to be held responsible. Then you get into the instructions, explaining all those convoluted things they've already heard. And then you end up with your ask, which is hold her responsible. So I think you're going to see a very structured, very organized, very traditional closing argument out of the state, very focused on the facts, the theme, and the law.
So I am getting messages from Ashley right now in real time, and she says that they're going over her messages again. You told me just less than 5 minutes ago how they started their opening statements with that message. Stay close to me. I'm going to be like Nephi. You're going to be like Nephi. It sounds like that is exactly what they are doing right now. And they're going through that. Now, Trina Kay, who's the prosecutor, she's going to be splitting out closing is what she says. First with the timeline, motives, and evidence. And then she says she's going to go over jury instructions and how she says Daybell is guilty beyond that reasonable doubt. So to that second question that I asked you is that she's going to be looking for those sleeper jurors.
Yeah.
She's going to be in the back half of her closing statements is going to really be honing in on those jurors and saying, here is why it's beyond reasonable doubt. Here is why it's beyond reasonable doubt in this case. I mean, what is Daybell going to have to do in order to combat this after a closing argument like this?
I think Lori Daybell is going to have to focus on a couple of those jurors. And you've got to remember, the jurors have sat there going on 2 weeks and watched her day in, day out. She's going to probably look at a couple of the jurors that she thinks have responded to her positively. The people who've made eye contact, maybe the people she smiled at, because the jurors aren't just watching the witnesses on the stand. They're watching both sides of the case. Sometimes they got nothing better to look at than the lawyers or the defendant. So they're going to be sitting there that whole time watching Lori, looking for connection. Lori's going to be looking for a connection for one or two of them. And she's going to really try to hit one or two of them and say, where's the evidence that I conspired? Where's the evidence that said I wanted him to pull the trigger twice? Where's the evidence that says I was responsible for Charles's death? Right? So I think she's going to hook her evidence on one or two jurors. I think she's going to try to get them to say there's no direct, overt evidence of a plan. And without a plan, you cannot convict.
And so then looking into reading the tea leaves here, do you feel like jury deliberations could last a while? Or do you feel like this is a cleaner case than we're thinking?
I think it's anybody paying attention to those texts and to the timeline, how that day unfolded, and Lori's reaction. I really think if jury selection, now I haven't been in the courtroom, so I wasn't part of jury selection. I don't know this jury. And so if the jury selection went well and people who couldn't consider circumstantial evidence, who couldn't consider convicting without a overt smoking gun, were eliminated, then this should not be a long, they will, depending on what time they get the case, they're going to get in there, they're going to pick their foreman, they're going to set their schedule, they're going to review, they may do a straw poll, and then they may decide to do some discussions and go home and sleep on it. But I think we should have a verdict certainly by tomorrow early afternoon. If it goes much past tomorrow mid-afternoon, then I worry there's an issue or there's confusion on the jury. But I think if jury selection went well and they weeded out people who couldn't consider circumstantial evidence, I think you're going to see a quick verdict.
And we're playing chess here. You have to look 1 to 2 to 3 moves ahead. I was talking with some local attorneys. They said that you have to know what your witness is going to say to your question. And there were some parts in cross-examination that Daybell seemed to ask questions that she didn't know the answer was going to come, and even was like, really? Just questioned exactly what they said that way. And so, do you feel like Daybell has been playing chess or checkers or from one hand behind? I mean, it's interesting to know.
Yeah, I'm so sorry.
Go ahead.
To me, Lori has been playing a lawyer on TV. She has, that's why you hear her use phrases people think you have to use. The evidence will show. The evidence will show. Well, there's nothing in the law that says you have to say those words. You just can't argue an opening statement. And brand new attorneys or high school mock trial team thinks if I throw that in front of it, it solves the problem. So Lori's conduct has been very much sort of somebody playing a lawyer on TV. She has not done a good job of advocating for herself. There have been things that are objectionable, not reversible, but objectionable, um, and come in. So it's really on Lori.
And then looking at Lori's closing statements, we have prosecution starting now, but then Lori, it has been an objection fest over all of the cross examination. It's been hearsay here, hearsay there. Do you think it would be smart for prosecution to be on their toes and ready to call out, hey, she's testifying right now in her closing statements?
You know, this is the hardest part about dealing with people pro se, which is what it's called in my jurisdiction. I know it's called pro per some places. It's you walk a fine line. You don't want to seem like you're beating up on somebody. So you have to be careful. So Trina's going to evaluate how much, okay, is the jury buying this? How much is this hurting me? Is she violating a court order? So we will see objections. We've seen them already. We will see if she's really getting into stuff that is not a reasonable inference, that has not come in. Then we will see her, the objection coming out of the prosecutor. If it's not hurting her, or it opens the door, or it causes something that the prosecutor, they'll hold back. You have to be careful when the other side is their own lawyer. You don't want anybody to think you're taking advantage or being, the courtroom bully.
Yeah. And so with the prosecution, let's play devil's advocate here for a second. Okay. You also have to think about what are the holes that have been poked throughout the past 2 weeks, because Lori has done everything she can to try, and even if it's the smallest hole, the smallest doubt, that's all she needs. So what are the holes that you think prosecution needs to tie or fill right now?
Yeah, well, the holes will be, there's no overt statement that says kill him now. There's no direct, when he walks in, claim self-defense. The other hole it will be, I think, is who has someone killed in front of their child. I think some of the questions that we heard from the jury, like, did Lori object to Tylee speaking? There was another question along Tylee. So I do think that the prosecution has to explain that this was conduct from two people who wanted him to die that day, who had a plan for them to die that day. They just didn't have all the kinks worked out.
And I've asked this of every single analyst because I just find it is so important for everyday folk, just like myself, who is, even if I've been following this case so much, there's so many. I mean, we're talking a 6-year saga here between where you're at in Idaho and the case there, but then also the cases here. We have 2 cases here now, this one, and then we have the one afterwards. If I were a law student and you were teaching me something to learn from this case here in Arizona, what's the lesson plan that you're putting together?
First of all, don't be your own lawyer. The second is really focus on what it takes to put a case together, and being very strategic in understanding how the jury, who knows nothing about your case, is going to see evidence. One of the biggest failings lawyers and defendants have in front of a jury is, your case so well, you forget that it's new to the people you're trying to persuade. So you focus on what the evidence will be, and be viewed by people who aren't you, and who, I jokingly say, normal people who don't see it the way lawyers do. Focus, don't get convinced of the strength of your own case, and don't forget that normal people react with logic and connection and emotion. So focus on your evidence from the outside point of view.
Yeah, you can get caught up in that web. You put the lawyer glasses on and you're like, well, I have this, that, the other. And then you realize, oh, these are a jury of her peers. This is
Yes.
a jury of her peers. These are people who, have probably not spent their whole lives putting together an argument in a conspiracy to commit murder trial. These are
Right.
people that are going to be paying attention to what you say. They're going to be looking at the emotional aspect of it. Yes, they're going to be looking at the evidence too, but they're looking at it from a more holistic perspective rather than the minutia of this little thing here and this little thing there. Although it is important to put on the record. We have just a few minutes, and I want to open this up to you. What are you looking at as right before we head into the courtroom to see this? What are the number one or number two things that you're looking to hear from the prosecution?
What I'm looking to hear from the prosecution is about the conspiracy, the evidence that showed not just that Lori benefited from Charles' death, but that Lori wanted him dead. So I'm looking to hear that timeline that they're going to put forward of the calls or the texts to Tammy, the emails to Tammy. I'm sorry, I correct myself. The timing of the life insurance, the timing of Lori moving into a house, and then when Charles comes to visit, he's dead that first day. So I think that time, I'm looking for the timeline. I'm looking for the helping the jury see past the natural instinct that a wife or a mother wouldn't do that. I'm looking for the connection of the dots and the emotional commitment to a conviction.
And I think I agree with you. I'm looking for them to really hone in on this is a conspiracy. And here is how it's a conspiracy without that, because I naturally, as a journalist, sit there and I say, well, I want to see that evidence. How does that evidence directly point to it? I need to see an arrow plainly, out there, because when you're dealing with something like reasonable doubt, that does put the burden on prosecution. But as you said, you believe that prosecution has done a pretty good job in showing that. I mean, they had well over 12 witnesses from everything from finances to religious friends to every single person, all the people that were at the scene, not every single person, but
Right.
the people of importance that were investigating on the scene, down to the medical examiners, to go back and say, hey, yeah, the officer said that the second shot couldn't have been done while he was standing up. Here's the actual evidence from his
Right.
autopsy that shows us that it was against a flat surface. It was a shore wound. So it's been a very fascinating case to see how they're really painting that bright red arrow that they can, and then have Daybell trying to metaphorically erase parts of that arrow. Oh,
Yeah.
well, did you actually do everything you possibly could? Or, just all of the things. So I think that they came at it from a very broad perspective, as well. And I think that even looking forward, so, one of the final things is, if we're looking beyond the verdict here, could the decision in this case then impact the way her second case in Arizona would go?
Yeah. Well, I absolutely. I think any verdict in this case, guilty or not guilty, I just can't process it would be not guilty. But
Yeah.
in fairness, I need to say that, right?
Yeah.
The will shape what happens on the trial involving Brandon. I think we will see different witnesses. The evidence is different. Some of it was heard in Idaho, but not all. We admitted what was enough to show it was part of a conspiracy that helped the jury understand the motive to kill Tylee JJ and her conspiracy to kill Tammy. So that was what was admitted in Idaho, which was very narrow. There's a lot more evidence involving the death of Brandon, the motive for wanting Brandon dead, and the actions of Alex and Lori and others to try to kill Brandon. So I think we'll see a different case, but it'll be the same approach. Very focused on Brandon, very focused on Arizona, very committed to getting Brandon's justice in Arizona, which again, I can't applaud Maricopa enough for doing that.
Thank you so much. I appreciate it. Rachel Smith, special prosecutor, who is on the Vallow Daybell case up in Idaho, and your analysis is fantastic. I appreciate you being a wonderful analyst for us throughout this whole thing. And like we said, this has already been a 6-year saga. This saga continues with getting us into court today, and obviously moving forward into that next trial. I think we're going to turn it over into the courtroom right now and start watching some of those closing arguments. Thank you so much.
No problem.
All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number I believe is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess. All right, the jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later, on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother, and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex, and they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message, this one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? A gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why. Responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is, in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car, and then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Santan. You see on her records that she, again, calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's flight reservations from Charles's phone. not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive. To Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages in Exhibit 230? It will be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad, the affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, Brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants, this is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. So what about those religious beliefs Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually. Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more, though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs, and she said pretty much after that the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him. Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say. Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation?
Correct.
She was open about it?
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words. From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody, again, runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself, conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day, and you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once?
Yes.
Can you describe for us sort of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says. but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so, as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th. Again, we have Melanie, who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is, from Detective Duncan and from Adam, that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that, in fact, we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles at center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees, when he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. 1, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, you couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30, pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around as he's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote, she is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on, time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. It's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. finally think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm. No questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th, in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, just because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him, or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door, according to Lori, and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclan, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclan that Tylee comes out with this bat. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
And so he put it in the car,
Okay.
in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened, how did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I wouldn't give him his phone. He was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking towards around the house with it, so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. So let's talk about staging the scene. we know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. He got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But what we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
Field with your brother.
Yeah.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Right, left-handed?
So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and
what happened?
then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still, because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards, almost in one arm.
Like he was swinging it backwards? He would have done like
he would have swung it backwards at me, not frontwards.
Okay.
So Lori Vallow, detective, and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen, down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coons told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun, within Charles 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and he doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it, someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point Charles is standing and shot, and we know that final shot he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband, who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. It's Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We've talked about a few things, but One of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. Oops. If this will play. When she was questioning Detective Enclan, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You know, not in Santan, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in here.
Gotcha. How long have you guys lived here?
I'm sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, the projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex, or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction under Presumption of Innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent whom we did not hear from in this trial. The state chose not to show you those interviews or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. Testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
All right. That's sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime.
and you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we, because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated.
You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers. 14. Juror 14. Juror 5. I don't think you're 5. Well, maybe you are. Okay, so To the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do.
Izzy, drop those off. One, drop those off.
All rise for the jury.
The jury is no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions. In the event that there is a verdict of guilt, the state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long. Got it. All right, we'll be at recess until we hear from the jury.
All rise.